All right, people. So, welcome to Jumbo IS and welcome to our lecture series on current affairs. Now, we have changed our strategy for current affairs a little bit. Now, we cover subject wise current affairs and weekly current affairs. Now, today we are going to cover polity related current affairs from the past 1 week. In the previous lecture, we covered economics related current affairs from the past 1 week. Today is polity, and tomorrow will be international relations. I have basically revealed the entire schedule, the entire weekly schedule to you in our previous video. If you want to see that, go check that out. Now, let's focus on polity related current affairs from the past 1 week. Okay, so without further ado, without further introduction, let's straight away dive into the lecture. But first, let's take a look at the list of topics that we shall cover today. So let's begin. So current affairs, Indian polity, and June 2026 part 1. As you know, every month has 4 weeks. So polity related current affairs or any subjects related current affairs would be covered in 4 parts. This is part 1. Part 1, 2, 3, 4 are still pending. Okay. Nonetheless, let's take a look at the topics. So first we'll talk about Assam UCC bill, Uniform Civil Code, a very controversial topic in the entire country. So Assam has become the third state in India to introduce UCC. So we'll talk about this. Then we'll talk about directions given by Supreme Court to high courts, okay, with respect to strict timelines for reserved judgments. Now, what are reserved judgments? Well, basically there is a case, all arguments, all proceedings are over. Now the court decides that I am going to deliver this judgment later, at a later date. This is known as a reserved judgment, and sometimes there are delays in that. Now, Supreme Court has said that let's bring strict timelines for it because this causes judicial delay. And justice delayed is justice denied. Okay, so basically, just a second. Yeah. Supreme Court has taken action in this regard. So we'll talk about this. Then we'll talk about another decision by the Supreme Court validating the SIR exercise, the controversial SIR exercise before Bihar elections. So we'll talk about this. And in the end, we'll talk about public health as a right to life matter. Okay, this is a very important topic. In fact, the Supreme Court has added another right in Article 21. Article 21 is your fundamental right to life and personal dignity, right? Now, ever since Menka Gandhi case of 1978, Supreme Court has been adding rights to this Article 21. Like right to privacy is part of Article 21 now. Right to clean environment is part of that. Similarly, right to timely health, timely trauma care in case of accidents is also your fundamental right now. Okay, so this is a very pivotal moment. So we'll talk about all these 4 issues. So these are the 4 news items that we shall zero in our attention on. So let's start discussing them one by one. Starting with topic number 1, and that is Assam Uniform Civil Code Bill 2026. Now listen to me very carefully. What is Uniform Civil Code? Uniform Civil Code basically means that all communities in India, that means all religious, all communities, all religious or all linguistic communities have same personal laws. Now, what are personal laws? Well, laws related to marriage, divorce, inheritance, right? All these things come under personal laws. Now, different religions have different personal laws. Therefore, there was this thing that, there was lack of similarity. For example, I'll give you an example. In Hindus, well, monogamy is there, bigamy or polygamy is strictly prohibited as per law. But that is not the case in Islam, legally speaking, right? Now, this is not an example of Uniform Civil Code. Uniform Civil Code means that all personal laws for all religious communities would be same, right? Now, India wanted Uniform Civil Code. That is why we included Uniform Civil Code in DPSPs, Directive Principles. But since Directive Principles are non-justiciable, well, you cannot enforce it because it is included in the Constitution, okay? Yes, you know about DPSPs. And the reason for that was basically certain communities want their own religious freedom. So in the name of that, well, they were allowed their own personal laws. But ever since the past couple of years, well, the debate around UCC has been heating up. And now, since it is really controversial for the central government to enact UCC, different state governments are enacting UCC in their own state. Okay, now Assam has become the third state to do that. So what are the provisions with respect to UCC in our constitution? What are the provisions of this UCC bill in Assam? We'll talk about this. Okay, so let's begin. So Assam UCC Bill 2026. Now, On May 27, 2026, Assam Legislative Assembly passed UCC bill through a voice vote. Now, this is a historic position because Assam has become the third state to do so after Uttarakhand and Gujarat. And Assam has become the first state in Northeast India to do so. Now, to understand UCC in a little bit more detail, you need to know what are the constitutional provisions. What does our constitution say about UCC? Okay, so let's begin with that. Okay, so Article 44 DPSP says that state shall endeavor to secure uniform civil code for citizens throughout the territory of India. But remember over here, it is written state shall endeavor. It is not mandatory for the state shall try. And since DPSPs are non-justiciable, you cannot hold the government accountable if they do not implement you cannot drag the government to court if they have not implemented any DPSP. They have been implementing DPSPs, but that is on their own accord. It is not mandatory for them. And since UCC is a little bit controversial, well, central governments have been reluctant to do so. Yet, DPSPs have said, if it is written in DPSPs, that means our constitution makers wanted this uniform civil code. So DPSP direction is there. Then, one more fact, constitutional fact with respect to DPSP, and that is very important for you to understand. Okay, our constitution has 7th schedule. In 7th schedule, the legislative powers of center and states have been divided. Okay, now 7th schedule has 3 lists. Okay, union list, which is list number 1. All the subjects mentioned in union list, only parliament has the authority to make laws over it. Then state list, this is known as list 2. All the subjects mentioned in state list, only state legislative assemblies have the authority to enact a law on it. And then there is list 3, which is concurrent list. Subjects mentioned in concurrent list, well, both states and center can enact laws on this. Now, personal laws or UCC basically comes under concurrent list. That means both union and states can make a law on it. But since it's really controversial for the central government to enact a law on UCC, because India is a very big country and a diverse country, whenever the central government would basically start the proceedings for legislating on this matter, there would be opposition voices. Therefore, the matter has been taken up by individual states. Since it is a concurrent list subject, individual states can enact legislations, and that is why Uttarakhand, Gujarat, and now Assam have done so. Okay. Plus, the thing is that this UCC bill of Assam is perfectly aligned with the new law of the center, which is Bharatiya Nyaya Sanhita. All the criminal clauses in Assam's UCC bill are perfectly aligned with BNS, which replaced IPC, Indian Penal Code. So it won't have any judicial challenge also, with respect to the criminal provisions. Right? Now, some key features of this Assam bill. Okay, what is written in this Assam bill? So this is there. Absolute ban on polygamy. Whether you're a Hindu, Muslim, Sikh, Christian, polygamy is prohibited. And it is a criminal offense. It can carry up to 7 years jail term. Okay, so no polygamy, only one marriage. That's about it. Then standardized minimum marriageable age. Marriageable age has been fixed, minimum marriageable age. It was earlier different for different religious communities, but now it is 21 years for boys and 18 years for girls. Plus, certain types of marriages have also been have been banned. For example, marriage between close blood relationships. There are 37 types of that. Well, they have been declared null and void. So no community would be able to do it. Then compulsory registration machinery. All marriages must be registered within 60 days. And this particular provision is with respect to inheritance. Different communities have different laws with respect to inheritance. If someone dies without a will, then their property is given to, as per the religious laws. Now, as per this law, their property will be equally distributed between blood relatives. Basically, children, spouse, parents, and within children also there won't be any discrimination between sons and daughters. That was there in certain religious communities. That won't be there. So this has been standardized. Plus, this UCC bill has also legislated on live-in relationships. Now states are regulating live-in relationships as well. Okay. live-in relationships. First of all live-in relationships, if a couple without marriage have decided to live together, well, they have to register it within 1 month. Okay, they have to do it. If they don't, well, there can be jail term, financial fine, or both. So they have to register their religious live-in relationship within a month. But there is some advantage to that also. If a couple bears a child in a live-in relationship, okay, that child won't be considered illegitimate, that child was not born out of a marriage. That child will have full biological rights, inheritance rights, everything, as if this child came out of a marriage. Okay, this advantage is there. Basically, this is for women only. Okay, now UCC is controversial all over the country. Okay, one reason for this controversy is, well, basically Muslim community opposes it because Muslim community is ruled by their own personal law. One thing is that. Then in India, tribals have been opposing it because tribal communities have their own personal laws, have their own marriage laws, customs, have their own divorce customs. They have their own thing. They don't want a uniform thing. They want to preserve and protect their own thing. Now, government is sensitive to that. That is why even in Assam's UCC bill, there is exception for tribals. These provisions won't apply to tribals. Any ST community in Assam, it won't apply to it. Plus, there are many areas in Assam which are tribal areas, which come under 6th schedule. Which these 6 scheduled tribal areas have been given autonomy. Okay, political autonomy. They have their own councils for governance. Okay, they have been exempt from this UCC bill. So, UCC does not apply to tribal populations residing in plains or within the 3/6 scheduled autonomous district councils of Assam. So, Bodoland Territorial Council is the region is exempt. Karbi Anglong region is exempt. North Kashmir Hills, Dima Hasao region is exempt. Tribals have been exempted from this. They can preserve and protect their own customs. Simple. Okay, that's about it. That's all you need to know. Now let's move forward to another news item, and that is strict timelines for reserved judgments. Now, what are reserved judgments? Okay, well, all proceedings are over. All oral arguments have been heard in a case. Now the Supreme Court is about to deliver its final judgment, but the Supreme Court reserves it, which means that Supreme Court will deliver that judgment at a later date. Now, what happens is sometimes there are delays in these reserved judgments. All proceedings are over, but sometimes Supreme Court, not even Supreme Court, all courts delay delivering the judgment because of XYZ reasons. And sometimes these delays can be as long as 1 year, 2 years, 3 years. Now, this is really sad for under trial populations or under trial people. Under trials are those who have been arrested, okay, they are in jail, but the final verdict is still going on in the court. I mean, whether they are guilty or not, the proceedings are still going on in the court. Okay, but they are still in jail, they haven't received bail. So if you delay reserved judgments, they would still reside in jails until the judgment comes out. Maybe the judgment would have been that this person is innocent, release him from the jail. But because of this delay, he'll still stay there in the jail. So Supreme Court has come out with strict timelines. There is a 3-month deadline for reserved judgments, and all bail applications would be resolved on the same day or max to max the next day. Plus, Supreme Court has come out with proper transparency framework. Okay, that all these bail orders should be published on the court's websites and everything. So this is there, right? Now, we won't focus more on the technicalities, though the technicalities are mentioned in your notes, but we just give a brief reading to that. But we would focus on the rights that are involved in this situation. Okay, so let's talk about this. So strict timelines for reserved judgments. Now look, courts believe that justice delayed. This is a very famous dictum. Is justice denied? Right? The Supreme Court, in its earlier judgments, have also said that if you delay justice, access to justice is delayed, well, that is a clear-cut violation of Article 21, which is right to life and personal liberty. So if justice is delayed, well, that is a violation of a person's fundamental right. That is why we need strict timelines for this. And that is why Supreme Court came out with strict timelines. In the landmark case of Pilapahan versus State of Jharkhand, the apex court invoked its special plenary powers under Article 142. Article 142 allows Supreme Court to direct anything to any authority in India, and that authority has to follow it. This is kind of a superpower for Supreme Court. Using this superpower, Supreme Court has directed this to all high courts in the country, that there should be strict timelines. What was the Pilapahan case? Okay, in the Pilapahan case, well, there were various tribal and OBC convicts, okay, serving life sentences. Now their final hearing was going on, but the judgment was reserved by the High Court, and it has been 3 years, but the judgment has not been delivered. They are still in jail. Arguments are over, court proceedings are over, but the High Courts are not delivering the judgment. The matter went to the Supreme Court, and Supreme Court says that this delay of 3 years is clear-cut violation of their fundamental right to life and liberty. Okay, Article 21. Therefore, from now on, all high courts would follow strict timelines. Okay, there is a 3-month deadline for such reserved judgments. Okay, plus in case of bail applications, well, the courts should hear all the arguments, and once all arguments are over, the judgment should be delivered. Bail judgment should be delivered on the same day or max to max the next day. Right? And in case there is reserved judgments are reserved for a period of more than 3 months, then this would happen. Registrar General flags case to High Court Chief Justice. Chief Justice issues final 2-week extension to the bench that in the next 2 weeks give the judgment. If still not pronounced, case is de-reserved and assigned to a new bench for re-hearing. Okay, this happens. Now, it's not that this is the first time that the Supreme Court has raised issues with respect to delayed judgments. There was a case in 2001, which was the famous Anil Rai case, in which the Supreme Court intervened and said that there should be strict timeline. I mean, there should be, the reserved judgment shouldn't be reserved for longer periods, right? This was the Anil Rai case, and in Anil Rai versus State of Bihar, the court suggested a general timeline. Remember, the courts did not give a specific timeline. They gave a general timeline that reserved judgment shouldn't be delayed for more than 2 to 6 months. Okay, but what was different in Pilapahan case? In Pilapahan case, first of all, it is 3 months, and the courts have given stricter timelines. Strict timelines. In Anil Rai, timelines were absent. Over here, timelines are there, plus publishing of all the case-related information on website. Transparency-related guidelines are also there in Pilapahan case. So whatever were the shortcomings of Anil Rai case have been fulfilled by Pilapahan case. This is something that you need to know about. That's about it. So there is some more information with respect to this topic in your notes, but just give 1 or 2 readings to that. But whatever we have discussed in the lecture, that is for you, that is important for you to remember. Right? Okay. Now, without further delay, let's move on to next news item, and that is validation of ECI's, Election Commission of India's Bihar electoral revision. Now, you all know about SIR, Special Intensive Revision. Okay, it was controversial in Bengal elections. It was controversial in Bihar elections as well. Right? Now, right before Bihar elections, this SIR was conducted. Now, what is SIR? SIR is Special Intensive Revision. Well, the electoral rolls, the voter lists are prepared afresh, and election officials go door to door to verify people's names on the list. Now, this is done so that all the duplicate, bogus entries in the voter list are removed and purity of voter list is maintained. So that, because purity of voter list is very important for elections, fair elections. Okay, voter lists should be genuine. Only then elections would be pure. And if elections are pure, then democracy is pure. So it is very important for the democracy as well, right? But opposition parties during Bihar SIR exercise they alleged that SIR exercise is unlawful and there is some bias in this exercise also. They even alleged that Election Commission of India is working at the behest of the government. So they challenged this SIR exercise in the Supreme Court. Now, the final verdict for this has been just delivered. And the Supreme Court basically took the side of Election Commission. Supreme Court delivered the verdict in favor of Election Commission of India. Now, what are the constitutional provisions with respect to that? What were the legal challenges made by opposition parties? What were the answers given by Election Commission of India? And what has the Supreme Court said in this entire matter? Let's take a look at that. Okay, so let's begin. So validation of ECI's Bihar electoral roll revision. So Supreme Court has validated SIR exercise in Bihar. Now, first of all, to understand this entire matter, you need to know about the SIR exercise in Bihar. What was the context? What was the background? So look, SIR exercise has been conducted before also. It is an exercise in which the electoral rolls, the voter lists are prepared afresh. All bogus entries are removed, deleted. Okay. Now, Election Commission said that, well, the last SIR that was conducted in Bihar was in 2003. It has been 20 years, more than 20 years. In that time, there has been rapid urbanization. There has been rapid migration also. People no longer reside in that area. They have moved elsewhere, but their names are still on the voter list. There have been numerous unreported deaths. There have been illegal migrations, duplications. So we need to purify electoral rolls. That was their idea. And on the basis of that, they conducted this SIR exercise. Yes. Now, opposition parties oppose this. They raise certain arguments in the courts. So we need to take a look at the arguments presented by opposition, litigants, and Election Commission of India. Okay. So what were the petitioners' challenge? First of all, they said SIR is a de novo exercise. De novo means never before, unprecedented, brand new. Plus, they said that it has no statutory backing. I mean, nowhere in any law SIR is mentioned. So, if it does not have any legal backing, why ECI is conducting it? So, this is point number one. Then, they said that ECI's documentation requirements, that when ECI is asking questions from you, they ask you to prove your citizenship, basically, whether your name should be included in electoral rolls, and they ask for a list of documents. Well, that documentation creates an unfair burden of proof on poor people who lack these documents, who rarely have these documents. So they are disenfranchised somehow. This was their argument. Plus, they leveled a serious charge also, and that was that in the garb of SIR, you are trying to delete various names from the voter list, somehow manipulating the elections. That is another serious charge. Now, Election Commission of India said that Article 324 says that Election Commission of India is entitled to conduct free and fair elections. And voter list purity is basically very important for fair elections. So under Article 324, it is our power, plenary power to conduct SIR, okay, to secure fair elections. Then Section 21, Clause 3 of Representation of People's Act also allows ECI to conduct SIR. So your charge that there is no statutory backing, legal backing for SIR, well, gets defeated over here. Plus, they said purity of voter list is the bedrock of democracy. And Supreme Court of India sided with these arguments of Election Commission of India. Okay, so this was there. But Supreme Court also, well, basically in their judgment, Supreme Court also balanced its judgment somehow. Well, many people were alleging that, well, people whose names were deleted from the voter list, well, they would lose their citizenship also. That point has been made clear by Supreme Court. Supreme Court has said that, look, the thing is that Election Commission is only entitled to handle voter list. If they are not able to verify a person's identity, they would delete their name from the voter list. But that doesn't mean that their citizenship would also get cancelled, because there are different provisions for proving your citizenship which are mentioned in Citizenship Act. For proving your citizenship, you will follow these procedures. Election Commission has no role to play in this. Clear? So this stand has been made clear that this is limited scrutiny of ECI. They will delete the voter roll. This is not their final judgment on a person's citizenship. Plus, the Supreme Court categorically rejected the Lal Babu Hussain case precedent. In the Lal Babu Hussain case in 1995, Supreme Court said that if your name appears in voter list, then that is proof enough of your citizenship. So if your name is there in the voter list, you are a voter, you are a citizen. Supreme Court says that this thing is not absolute. If your name is there in the voter list, and still if there are some evidences proving that your name was entered fraudulently, your name can be deleted. This is no proof. So Lal Babu Hussain case precedent has been done away with. Well, the opposition parties were using this previous Supreme Court judgment, which the Supreme Court this time around said that this is not absolute, irrefutable. Okay, so they rebuked this basically. Clear? That's about it. And now let's move on to last news item of the day, and that is public health as a right to life parameter. So look, there are so many road accidents, so many accidents that happen in India. And in case of accidents, there is this very specific thing that everyone is aware of. That if that person who suffered an accident, well, if that person is given trauma care, emergency care, in due time, without wasting much time, that person's life can be saved. But if you delay that, well, then that person loses their life. Well, the Supreme Court in its previous judgments have said that lack of access to timely emergency care in case of accidents is a violation of fundamental right to life, Article 21. Therefore, do not violate this fundamental right of citizens. Every road accident victim or every accident victim or every trauma victim should be given timely trauma care. Timely is the important word. Okay. Now, in its previous judgment, Supreme Court has already said that this is Article 21, access to timely trauma care. This is Article 21. But still, many people have died in India because they did not get access to this timely care. So Supreme Court this time around again intervened, saying that now we would ensure that every citizen gets timely trauma care. So they have given directions to various state governments to take steps so that every accident victim gets timely care. Now, what are those steps? Let's talk about this. Okay. So public health has a right to life parameter. So this case was in which the Supreme Court gave this judgment. Save Life Foundation versus Union of India. Okay. Now I told you in previous judgments of Supreme Court has said that access to timely trauma care is part of Article 21. But this time in Save Life Foundation case, Supreme Court has given active directions to the government to ensure that the Article 21 of citizens is fulfilled. Right? But what were those previous judgments in which this right was made part of Article 21? Parmanand Katara case, Paschim Banga Khet Mazdoor Samiti case, S. Rajashekharan case. Okay? But despite these judgments, states were not that proactive in ensuring timely emergency care. So in Save Life Foundation case, Supreme Court has given strict timelines, strict deadlines to all states to ensure these steps. In fact, Supreme Court has given certain steps that every state has to follow, and they have to follow that within 3 months. Now, what are these steps? Okay, key pillars. Well, different states have different helpline numbers for ambulances. You know, there is a number for ambulance, right? In some states, it's 112. In some states, it's 190. Well, the Supreme Court has said that unify this. All across India, there will be one single number for ambulance, and that is 112. So a 3-month target has been given to all states to merge their ambulance numbers with 112. Okay, this is done so that there is no ambiguity. People are not, they're not confused which number to call. Then standardization of ambulance infrastructure. There are proper rules and regulations with respect to how ambulances should be designed, how they should travel, what facilities they should have. It is mentioned in National Ambulance Code. All public and private ambulances all across India should follow this. Plus, all ambulances should have GPS tracking also. Like we can track Ola Uber cabs, ambulances can also be tracked now. Then, states must grade and designate all public and private medical facilities. So there will be grading of all hospitals, public or private, and the states will specify on their website that how many beds are there in the trauma care, emergency care of each and every hospital. Plus, every trauma case shall be registered in National Trauma Registry. Plus, all people involved in treating patients of trauma care, whether they are technicians or doctors or nurses, well, there will be a single unified protocol, steps that they should follow to treat such patients all across India. Plus, emergency medical technicians, EMT, they are basically trained at different institutes. But different states have different curriculum for that. Standardize the curriculum for emergency medical technicians all across the country. This is there. Okay. Plus, there is a central scheme called PM Rahat scheme for accident victims. But some states have implemented it, some states have refused. Supreme Court has said that all states should implement this. Plus, sometimes in case of road accidents, the people around are reluctant to help that road accident victim because of the fear of harassment by the police, because the police are going to ask innumerable questions. They would ask you to come to, they would summon you to police stations. So people are reluctant. So basically, all states should enact Good Samaritan grievance redressal systems. These people, these bystanders who help accident victims, they're called Good Samaritans. Well, if they have any complaint against the police, well, there should be a proper grievance redressal system so that police do not harass them, so that lives can be saved in time, so that your Article 21 is protected and preserved in such a case. Clear? And that would be all. With that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. But it will add more value if you're number one, consistent and regular with this lecture series, and number two, you revise this lecture from the notes provided by us. Because only then you'll be able to solidify these current affairs in your memory. Otherwise, you'll quickly forget them. So please do not forget to revise these current affairs. The notes are available on our Telegram channel, and the link to that Telegram channel is provided in the comment section below. Okay? Okay then. On that note, I'll be signing off with the promise of seeing you again with another lecture on current affairs. Thank you, everyone.